The Maryland Court of Appeals upheld the state's handgun laws and saying that despite the Supreme Court's ruling in Heller that the Second Amendment does not protect a person carrying a firearm outside of their home. Your thoughts on the ruling?
Well, that's clearly inaccurate. The specific issue in Heller was possession in the home, but the court analyzed in great detail what the term bear arms means, because D.C. had argued that it's a military meaning only, bearing arms in a military, and that keep arms means nothing. And the court clearly said bear means carry, and it relied on a number of 19th century cases that talked about the bearing of arms, carrying concealed weapons. It's very clear in Heller, keeping arms meant, for example, possession in the home, but bearing arms meant carrying, either concealed or openly, in places that people would normally carry guns, non-sensitive places. The court mentions that the restrictions on carrying guns in sensitive places like government buildings and schools could be prohibited. And those were the kinds of traditional regulations that were presumptively valid. But by implication, non-sensitive places, like where Mr. Williams was carrying his gun, were constitutionally protected. One thing that struck me is that the Maryland High Court tries to cite cases from other states that uphold, in the case of, for example, California, restrictions on carrying concealed weapons. As a matter of fact, California allows the open carrying of handguns. Maryland prohibits both open and concealed carry. So even the precedents that were cited were not appropriate.
Yeah, that's interesting. And and Charles Williams, he made clear in the arguing this case, as you were saying, he made clear the right of persons to keep and bear arms was for lawful purposes. That's what came out of Heller. But not
Heller
only
talked about a fundamental right to possess guns for self-defense, and again, although the focus was on in the home, the court said actually that the framers and the people at that time were more interested, instead of the militia, they were more interested in carrying guns for self-defense and for hunting. And carrying guns for self-defense and hunting typically involves carrying them outside the home. Now, the state made the argument, and the court accepted it, that, well, in Maryland there's a permit system, and out of the number of people who apply, a large percentage are granted permits to carry. But that's only because people in Maryland know they're not going to get permits. They don't waste their money applying. It's clear from other Maryland court decisions upholding permit denials that most people cannot get them. And in fact, if you look at the Maryland regulations on what it takes to be approved for a carry permit, it's just about impossible for an ordinary citizen to get a permit. They talk about things that make you unique, or that very specific kinds of reasons, and that ignores that the people at large are protected in their right to keep and bear arms. I mean, the Second Amendment refers to the people. And now many states shall issue carry permits to allow carrying concealed weapons. I don't dispute the validity of those. But what I think is inconsistent with the Second Amendment is the idea that the police have to determine that you have a need to carry a firearm, whether openly or concealed, and that what they think about your need is pretty much dispositive in every case.
Yeah, and as you're saying, the judges said that Williams, and I'm quoting them, didn't have a standing to challenge the aspects of the state's gun permit statutes because he failed to even apply for a permit to wear, carry, or transport a handgun. And as you were saying, we all know it's impossible to get a permit in Maryland.
That's like, a black person applying to vote in the Old South. I mean, there's a doctrine of futility that if it's futile to do something, to require a person to do something, they cannot make that a condition of you having standing. And not only that, the way the Maryland law is administered, and the way, just facially, the way it reads, all these qualifications you have to exercise Second Amendment rights, that's just not accurate. And I have to say, Mr. Williams is a law-abiding young man. He has, before this, had no criminal record.
He legally bought the gun.
He legally bought the gun, and the court gave him 3 years incarceration, suspended 2. So this young man's got to spend a whole year in jail or prison unless this case gets reversed. And it's just incredible. You could get that kind of felony sentence for mere exercise of the Second Amendment right.
Yeah, and you look at all the thugs that repeat offenders that are back on the street. The whole system. It's just all upside down. It really is.
Well, to use the criminal justice system to go against law-abiding people like Mr. Williams is just mind-boggling that the resources are spent that way, and that judges find a way to try to nullify the Supreme Court's decision, clearly holding that the Second Amendment means what it says. You have a right not just to keep, but to bear arms.
Yeah, and we all know Maryland's anti-gun, but the court's right behind them.
Well, that happens. We have a judicial culture in this country. A large part of it was very hostile to the Second Amendment. You had a number of courts talking about collective rights and denying that individuals had any Second Amendment rights. And so now I think what we're seeing is a trend among some courts to basically not recognize the Second Amendment in its full meaning as the Supreme Court has stated it.
And basically to nullify McDonald and Heller.
Well, that's right. I mean, every case has its own specific facts, but when you get holdings like you have in Heller and McDonald that about the meaning of the Second Amendment, the fact that the Maryland case involves different facts doesn't mean that the words of the Supreme Court don't apply. And those words are that we're talking about a right to keep and to carry firearms, that handguns are constitutionally protected. That was the type of gun here.
So what do you think happens now with this case?
Well, the only recourse other than a petition to rehear, which probably would not be granted, would be to file a cert petition with the U.S. Supreme Court and to see whether they might grant review.
But when you look at this, Steve, the implications of this decision, your concerns about it?
Well, it's the fact that an ordinary citizen, a law-abiding citizen like Mr. Williams, and people at large, you've got to fight tooth and nail for your constitutional rights when the court should be on top of the heap protecting those rights.
Right.
And when you have a tendency of some judges not agreeing with the full scope of those rights and thereby obstructing them.
And I don't know anything about these judges. I don't know what their backgrounds. I don't know what their beliefs are in the Second Amendment. But it all goes to that whole concern about judicial activism and legislating from the bench.
Right, and I would never attribute bad motives to anybody, a judge or anyone else. And I don't in this case, but I think what we have is a failure to recognize the full impact of a court decision based on a legal and political culture that for many years has been adverse to Second Amendment rights.